Court is now back in session. Please be seated.
Welcome back after that unscheduled interruption. We will continue our argument in number 221197, which is still Commonwealth versus Squadrito. We were in the middle, and I'm sorry your argument was interrupted, Attorney Slyman, but we were in the middle of Attorney Slyman's argument for the Commonwealth. I believe the clock was at 4 minutes and 3 seconds when we stopped, so I'm going to give you at least 3 extra seconds because now it's at 4.
Thank you very much,
I'm
Your
just
Honor.
saying. All right, you were talking about the closing argument.
Thank you. And Your Honor, I believe we left off with a question from the court as to whether the redness and swelling, is it a fair inference for the prosecutor, if we classify it as an inference that she's suggesting to the jury, whether that's fair to make. I think, yes, purely on the evidence alone, that these documented redness and swelling.
And that's because of the within normal limits.
That it was not within normal limits.
Okay, but I guess my question is still this. Within normal limits if someone hasn't had sex just now?
I think that question is left unanswered.
Well, so how can the prosecutor argue that that's how it should be interpreted?
Because I think even absent, I think that just the mere presence alone of redness and swelling classified, even if loosely, Your Honor, as not within normal limits.
Well, we're not going to be sending people to jail for redness and swelling without some testimony that the redness and swelling is consistent with sexual assault, right?
And if that was the only evidence presented in this case,
But it was the only evidence presented on this theory, right? The primary theory was incapacity to consent. And this is a statement that even if the victim was capable of consenting, here's your evidence that she didn't consent. It's redness and swelling.
Again, Your Honor, I would disagree that that is what's being put forth when you look at exactly what the prosecutor said here, that is what's being put forth. At most, I think that it is possibly an inference that's being put out there.
Say that again?
I'm sorry?
I lost
I think
a lot.
at most, perhaps it could be classified as an inference that's being suggested, but I think when you, again, look at the plain language of what the prosecutor said, it is not being presented as an inference. But regardless, this is, even if, and the Commonwealth in no way concedes this point, even if it was deemed error that it was putting an improper characterization of evidence in the record, it was done in response to the defendant's closing argument that there is no evidence of violence here, which is also unsupported.
Huh.
If we
Did you move to strike that?
No, it was not, Your Honor.
Okay, so you don't get two wrongs don't make a right. You don't get to respond if that's wrong. You don't get to respond with something wrong.
I appreciate the court's point on that. I would point the court to, I believe it was Ramirez, which was cited by my brother, where it's on page, I'm sorry, I'm looking at a printout of the case, but the court does look at the fact that the defense counsel's own argument referred to the very evidence which on appeal for the first time the defendant now claims was excluded. I mean, we're dealing with a different factual situation there. In any event, if there was error in the prosecutor's reference to urinary tract evidence, such comment was in response to the defense counsel's remarks and therefore invited error. So even if
what year was that case?
this was, it's an unpublished decision from 2009.
Okay.
And so.
Because we have published decisions that say you don't fight fire with fire and so on. But I also have to say, it's not clear to me that there is evidence of violence. So it's not clear to me that the defense counsel said anything wrong because there's no expert to say this is evidence of violence, just redness and swelling. I mean, you know how it's described here, and it doesn't. What I'd actually say is I have no idea. I have absolutely no idea whether this is consistent with consensual sex or a smoking gun for a sexual assault. I just have no idea.
This case differs from Ramirez and Harabach, the other cases, in that this falls more into, I believe as Justice Ditkoff suggested, a situation of the jurors can rely on their own common sense and experience of what would be experienced.
I can't speak to the jurors, but I have experience in common sense, and I have no idea. Do you know whether this is, using your common sense and experience, whether this is consistent or inconsistent with consensual or non-consensual sex?
I think hearing and seeing documentation that there was redness and swelling not within normal limits, that would allow me with my common sense and experience to reach an inference that is not necessary to reach the verdict here, but that would
Well,
suggest
if you reject the incapable of consent argument, which one might, I have no idea what the jury did, but the defendant describes conversation with the victim that is consistent with someone actually describing their obviously I don't know who's telling the truth, like I don't know anything about that. But, right, you might say like, well, I don't know. But you have the smoking gun on violence, that's a different matter.
Sure, Your Honor, sure. It certainly is not the smoking gun in this case, and I point to the other evidence, the victim's own testimony of what had taken place, the evidence that directs against the defendant's own credibility. So this is just a piece of evidence that goes towards the greater case that's being proven here. And I think regardless of all of that, the jury was properly instructed both before and after closing that closing arguments are not evidence, use the evidence that was put in front of you. So again, even if there was error here,
okay,
they were properly
I've given
instructed and there was
some extra time, but if there are no other questions from the panel, thank you very much.
Thank you.
Excellent arguments, both of you, very helpful to us. And the case is submitted.
Thank you.
We will next hear argument in number 23-478, which is Commonwealth versus Medina. We will hear first from you, Attorney Kaminsky.
Good morning, Justice Rubin and the rest of the panel. May it please the court, Keith Kaminsky on behalf of Julio Medina. This is a OUI case with a single vehicle crash. The Commonwealth failed to present sufficient evidence of operation. Mr. Medina wasn't in the driver's seat. He wasn't the registered owner. He denied driving the car, and he had no injuries on him, despite the fact that the car crashed on 93 South hard enough to pin the driver's door closed. The Commonwealth points to a footprint in, the back seat, on the back of the driver's seat, as evidence Mr. Medina was driving. The problem with that is there's, no evidence linking him to the driver's seat. There's no footprints. He couldn't have opened the driver's door because it was pinned closed.
I thought it was the passenger's door that was pinned closed.
The driver's door was pinned closed by the crash, not the passenger's door. And the other evidence the Commonwealth points to is the fact that the seatbelt was belted in incorrectly. The trooper testified it was, 2 buckles over. You're in the rear seat, you got a bench seat, and, if you're a larger person, you're not going to be able to reach that first buckle there. The other thing to keep in mind is it is a crime not to be seatbelted.
Wait a minute. Is there any evidence that he was a larger person? Isn't the point of being, and it's not the next buckle over, it's 2 buckles over.
Right. But the trooper testified that it's 2 buckles over, so you need at least 3 seats in the back for that. There was no evidence he was a larger or smaller person, no observations about that presented at trial.
Could the jury infer from the fact that your client was in the back seat that the front seat passenger was not the driver? Because if there were 2 people in the car and one of them was the driver, then the second one would sit in the front seat, the front passenger seat.
That's an excellent question, and yes, usually when you have 2 sober occupants of a vehicle, they both get in the front seats. However, Mr. Medina was heavily intoxicated. It's likely he could have been loaded in the back seat, and we don't have any testimony about what happened earlier in the night if other passengers were dropped off. The jury and the trooper both had to speculate that it was only those 2 people who got into the car. I would also point out that the cases the Commonwealth cited, all of them, either the registered owner or the person in the driver's seat was found to be the operator. And the only case that was similar where, you had two people in the front seats was Commonwealth v. Doyle. In Doyle, the crash pinned the passenger into the passenger seat, and the defendant was seen trying to drag him out of the passenger's seat despite the fact that it was pinned there by the crash. Also in Doyle, witnesses saw the defendant and the victim leaving together, so you can infer from that that there were only two people in the car. We don't have that here. It was, 2 a.m. in the morning. People had been out drinking and they were returning home. We don't know if the owner was dropping off more people or who was driving, because the evidence was insufficient. And that's kind of the theme of this case. The trooper, he came up to the car. The first person he saw was Mr. Medina. And after that, he was just blinded by primacy bias and continued to question.
Which kind of bias?
Primacy bias. The first person you see is the first person you're going to focus on. And that's what happened with the trooper in this case. Turning to the second argument, the trooper's opinion that Mr. Medina was the operator, and then listing all the evidence to support that, that wasn't proper testimony. There was a motion in limine argued on that. That was denied. The case.
I don't really understand what's improper about that testimony.
What's improper is his opinion on one of the elements in this case, the only contested element of operation, that Mr. Medina was the operator, and then listing the evidence is never proper testimony.
But it's not an opinion of guilt, it's an opinion on one element. I thought that the rule prohibited, we have officers all the time say, I reached the conclusion that the defendant was impaired. What they're not allowed to say is, I reached the conclusion that he was operating while impaired, because that's the crime. So he's giving an opinion, or she's giving an opinion on the crime. What's your best case for just one element being impermissible?
I'm glad you gave that example. When you look at opinions on sobriety, you go back to what is the basis of the testimony. And the basis for that is common experience. The trooper is just summarizing what he sees. In this case, the trooper clearly testified he wasn't testifying from his prior experience or his training. He just made the speculation or conjecture that Mr. Medina had been operating.
But then the objection is that it's speculative, not that it's an opinion on an ultimate issue.
Correct.
Okay.
And in this case, to the extent that operation was the only contested issue at trial, well, actively contested issue at trial.
And why doesn't the crying do anything for you?
So Mr. Medina was in the back seat and apparently was not seatbelted in correctly. Now, it is a crime in the Commonwealth to be in a car and not be seatbelted in when it's in operation. And for whatever reason, he's also heavily intoxicated. So this is the defendant's position that drunk man's tears aren't really probative of anything in this case. And once again, he was so intoxicated, he needed to use the car for assistance to get out of the car, and the troopers stopped the field sobriety testing.
Counselor, in cross-examination, defense counsel asked the officer, you must establish the driver is operating or an actual physical control of the vehicle. Your observations and documentation must establish the driver is operating or an actual physical control of the car, and then goes in on all the circumstantial evidence that should have led the officer to believe the defendant was not operating. So after that, why isn't it proper in response to that, as happened here in redirect, for the prosecutor to say, so why do you think he was operating, when the defense counsel asked the officer about his opinion in cross?
It is proper as to the scope, but if you look at the SJC case, Commonwealth v. Lodge, they lay out exactly the same scenario. And what the Commonwealth is supposed to do in this situation is go through each decision and omission that the trooper made when he was confronted with this situation. What what the Commonwealth is not supposed to do is elicit an opinion on guilt followed by, a recitation of every piece of evidence supporting that. And the SJC made that very clear in Lodge. Seeing no further questions from the court, the defendant would rest on its brief.
Thank you very much for your argument. We will hear now from Attorney Semple.
Good morning, may it please the court. I'm Catherine Semmel on behalf of the Commonwealth. With regard to the sufficiency of the evidence, I would just reiterate what I think were the major points, that the driver's side door was pinned against the guardrail, which meant the driver couldn't have gotten out that way. The fact that there was a footprint on the back of the driver's side seat, which the officer testified was a strange place for there to be a footprint, that the defendant was then in that back seat, that he was wearing sneakers, and the officer thought it was a sneaker print. The idea that the seatbelt was buckled 2 buckles away, and finally that the defendant started crying when the officer pointed out the odd way in which he was buckled in the back seat. And I think what distinguishes this case from some of the other cases, such as Muller and Leonard, is just that there is some physical evidence, there are some circumstances at the scene that could lead a reasonable juror to find that the defendant was in fact the driver. It's not pure speculation at all. There are facts that make it more plausible, and jurors could accept or reject that, but there was certainly something there and enough for a jury to look at that and determine, not that it's just 50-50, but there's reason to believe that it was actually this defendant.
Well, there's none of this dirt of the type that's on the back of the seat in the footwell of the driver's side, right?
That's what the officer testified, the trooper testified, sorry.
And sneakers seem pretty common.
Sneakers are, certainly, I mean, it's not DNA evidence, it's.
No, but it has to be beyond a reasonable doubt.
Right, but I think all of these circumstances together, all of these circumstances added to which the trooper, his opinion was that the front seat passenger, he also added that he thought the front seat passenger was too inebriated to have even had the wherewithal to move.
They both sound pretty inebriated.
They were pretty inebriated, and I would add one additional factor that I left out, which is that the trooper passed the car, first going the other way on the northbound side with lights on. So somebody certainly had time to move, which obviously somebody did, because nobody's in the driver's seat at all.
Well, somebody obviously moved. There's no one in the driver's seat.
There was certainly time for the defendant to move, to scramble into the back seat, which a juror could determine was consistent with the footprint there in that odd place, the seat buckled by somebody.
I don't actually see how it's consistent with the footprint on the back of the seat. The rest, I get what you're saying. I don't understand how climbing from the front to the back gets a footprint on the back of the seat.
I don't know either. And I don't know that it's the climbing so much as the positioning in the back seat after you get there. I could imagine that. I haven't done a lot of such scrambling myself.
We have no photograph of that?
There were no photographs, and the trooper was cross-examined to some length by the defense about that and explained that he had only his personal cell phone, and they're taught not to make that evidence in a case. So yeah.
Do you know which direction the footprint was pointing?
No, I don't, sorry. And I don't believe it was I don't think it was in the police report that way. Yeah, so on all these bases, I mean, obviously this is a very fact-specific inquiry. I pointed you to several cases where there were not, like, incredibly compelling facts, but enough for a jury to determine. And I think this case is comparable. I think the crying is an important factor in terms of consciousness of guilt, in terms of, pointing out, basically the officer has caught him, and determined, what he has done, and that the defendant started crying, and that all of these are bases that a juror could rely upon. And it's not just speculation to say that it was the driver who was driving on the facts of this case. It's very consistent with everything at the scene, including the pin door.
We know nothing else about the passenger except that the officer said he thought he was too inebriated to have moved from the driver's seat to the passenger seat.
Yeah, I don't think there's anything further in the record.
Do we know how long ago they got in the car?
No.
And there was no empty liquor or beer bottles or anything in the car. There was no sign that they had been drinking in the actual passenger compartment.
Right. There's no evidence of that. And I believe the defendant said they had been drinking,
It's a pretty
previously.
weird case. Nobody in the driver's seat is unusual, I think. But.
Yeah, so for that reason, we would argue that the evidence was sufficient in this case. I'd be happy to talk about the second issue a bit. I think it's certainly clear that giving an opinion that the defendant was the operator does not go to the ultimate guilt or innocence. It's not Hesketh. It's not the case law that was distinguished in Canty, and I think Canty really made it clearer because I think the case law was a little confused prior to that as to when it's okay and when it's not okay generally. And in this case, where it didn't go to the ultimate guilt or innocence, I think that the judge was well within his discretion in allowing it. And for the reasons that have already been pointed out by the panel, it was not deliberately elicited by the Commonwealth on direct in any event. It was properly elicited on redirect to rehabilitate the trooper as to all the reasons that he thought supported the fact that the defendant was the operator. And in any event, jurors, assuming there was any error in any way, jurors would have been well aware that the trooper believed that the defendant was the operator from the fact that he gave him sobriety tests and placed him under arrest in the case. If the panel has any further questions, I'd be happy to answer them, but.
I see none. Thank you very much. Excellent argument, both of you. Thank you very much. Very helpful to us. The case is submitted. We will next hear number 22-1227, personal representatives of the estate of Margaret Ross versus Gretchen Dietrich and others. And we will hear first from Attorney Tennyson.
Good morning. May it please the court.
Oh, wait, our timer. No, it's going. Go ahead.
Okay. This is a medical malpractice wrongful death case. I represent the plaintiff appellants in this case. Long before the trial, a motion was filed for attorney-conducted voir dire along with proposed voir dire questions. The voir dire questions were revised slightly the day before the trial, in large part to reflect that one of the defendants, a nurse practitioner, was no longer in the case, but there were a couple of other additional questions. Now, under Rule 6, questions that are presumptively proper would be those that reveal preconceptions or biases relating to the identity of the parties or nature of the claims or issues expected to arise, and inquire into the prospective juror's willingness and ability to accept and apply pertinent legal issues and instructions. In this case, I asked that the jury be asked a series of 12 questions, whether they had feelings against medical malpractice cases, whether they would tend to favor the doctor even a little bit at the outset before hearing any evidence. Excuse me, fighting this cold.
That's all right.
Whether a patient's family should be allowed to sue a doctor for money damages if the patient has been injured and died as a result of the negligence of the doctor, whether they require more than negligence, whether they require intentional misconduct before they could hold a doctor responsible, whether they'd require a consensus among medical experts before they could find.
Okay, so let's say the judge concluded that these were a little argumentative, or a little, I don't know what the phrase is that's indoctrinating, that they are designed, or I won't say designed, but that they, in fact, might serve to overemphasize certain rules, or certain parts of the law about the case to the exclusion of others. And so the judge says, well, the way you wrote them, I'm not going to ask that. Would that be an abuse of discretion?
I think it would, Your Honor, and here's why. The rule itself talks about questions that would cause prejudging the case. And those typically involve a hypothetical and then asking the jury to make a commitment that they would vote one way or the other. These were much more open-ended. They were seeking only to determine, do you have feelings against medical malpractice cases? Are you going to require more proof than a preponderance of the evidence?
They're going to be instructed not to do that, right?
that?
They're going to be instructed not to do that by the judge at the end. Like he's going to say, or she's going to say, it's a preponderance of the evidence, right?
That's correct. But if we look at the Superior Court Rule 6, those are precisely the types of questions that are proper. Inquire into a prospective juror's willingness to an ability to accept and apply pertinent legal issues as instructed. So that's part of the voir dire
Now, if
process.
the judge wanted instead to, because she or he didn't want to indoctrinate or indicate emphasis in any direction, to simply ask the party in a medical malpractice case, let's make it a little different than what the judge did ask. In a medical malpractice case, would you favor either the doctor or the patient? Either. Good enough?
Good enough.
And what did the judge ask? He asked in a medical...
He asked instead,
Do you have any strong feelings about people who seek money in a lawsuit?
that was one of them, but there was another. Is there anything about this case that gives you concern about your ability to be fair and impartial juror and your ability to render a true and just verdict based on the evidence and the law that's presented to you? No juror is going to say...
No, that's not... I mean, okay, so I've seen cases, and it seems appropriate to me, in race discrimination cases where the jury is asked something like, if you heard that the defendant had used a racial slur, would you be more likely to find them guilty? If like that. So it's clear that you can ask specific questions more tied than just impartiality to maybe doctors, maybe patients. Justice Grant's pointed to the question about do you have strong feelings, meaning do you think that they're just money grubbers who make false claims? Those seem appropriate to me.
So I think it is appropriate. They just don't go far enough. And that's the problem. And it never gave me the opportunity to ferret out those jurors who have reservations or leanings at the outset of the trial before hearing any evidence on all these very key topics. These are actually...
Why isn't it better for the judge to explain what the case is about and then ask the general question, is there anything about this case that would affect your ability to be impartial? What if a juror thinks, oh, that lawyer looks just like my ex-husband, I hate him already? You're not going to ask that question, but that might be bias.
So, but here's the thing. If we have a judge sitting up on the bench, elevated above the jury, and asking, can you be fair and impartial? The likely answer is going to be, I can do it. But that's why attorney-conducted voir dire is so important. That's why the ability to ask these very general, these are not loaded questions.
Some of them are a little loaded.
I thought they were pretty neutral.
Well, even a little bit? Will you be for the doctor? Even a little bit? That's a little loaded.
Okay, well, wait. So you mean leaning? So would you lean one way or the other, even a little bit before the commencement of the trial?
I mean, you don't emphasize the even a little bit just then, but
Yeah.
I mean, even a little bit, I don't know. Asking if they lean might be okay, it seems to me. But part of the problem I'm having is with the standard of review here, right? If it were legally required and not an abuse of discretion standard, then it's harder, you know, but it's abuse of discretion.
So that's correct. But here I submit there was an abuse of discretion. These are presumptively permissible areas of inquiry, and not one was allowed. And it gets a little bit worse during the questioning of the very first juror, prospective juror, who was a registered nurse. The judge asked those very open-ended questions, can you be fair and impartial, those types of questions, and then asked if I had any questions, and I said I did. And so I asked the nurse, bearing in mind that you're in the medical profession, and this is a medical malpractice case, do you think you might tend to lean in favor of one party or the other before hearing evidence? I submit that's a perfectly legitimate...
But you asked about a starting line.
Oh, sorry?
Right? Your first question that she
Yeah,
didn't understand
right, she didn't
was
understand.
about a starting line. Now, that starting line question, I'm not saying that every judge would kick it out, but I don't think it's an abuse of discretion to say, like, I mean, first of all, you're asking about yourself. I'm standing here in front of you. Would I be starting behind the starting line? I mean, you're the lawyer, right? I mean, it's you just represent a party.
Of course.
I mean, there's like that phrasing. I can see a judge objecting to that, and I don't think that would be an abuse of discretion.
What about the leaning question, though, Your Honor? Would you tend to lean in favor of one party or the other before hearing any evidence? I think that's an entirely appropriate question. And what of course happened...
Counselor, Rule 63C says...
Get there, yep.
The trial judge shall, at a minimum, allow the attorneys or parties to ask reasonable follow-up questions seeking elaboration or explanation concerning juror responses to the judge's questions or concerning any written questionnaire. Since the rule says that,
Right.
isn't it okay if the judge decides to just do that minimum?
Well, I submit not. But at a minimum, on that inquiry, that should have been permitted. That's an appropriate question. But we also have to look at what Rule 6.3c with 3c provides, and that provides that there are certain areas of inquiry that are
No,
presumptive.
it says you should generally approve certain questions, but it says at a minimum, you have to allow follow-ups based on the judge's questions and the written questionnaire. So if the rule says that's the minimum, how can we reverse for a judge only doing the minimum?
Because if the rule says that it should be generally approved, and none of the questions were permitted, even though I submit they are appropriate and were gauged to reveal implicit or explicit bias and the willingness to follow the law, I would submit it is an abuse of discretion not to allow any of those questions.
So how were you especially prejudiced?
Well, that's an interesting question that I've wrestled with a bit because I can't prove that I would have won the case. However, we were deprived of the protections of the statute permitting attorney-conducted voir dire and the protections of Superior Court Rule 6. It is as if they were just thrown out the window.
But it seems like you're arguing for structural error, which doesn't happen in civil cases, and specifically by statute doesn't happen in jury selection. You've got to show special prejudice.
But if we weren't afforded the opportunity to determine whether or not we had an unbiased jury, then we are prejudiced.
How?
Because we can't know what was going on in the jurors' minds during deliberations. We were never given the opportunity to ferret out any of these issues during the voir dire process. I submit that by itself is prejudice.
We do have cases where the burden on prejudice goes the other way. For example, the public courtroom cases, where you can never tell what the consequence of not having a public courtroom is. How can you tell? It didn't happen.
Right.
You know, and in that case, it's presumptive, although I think the government can come in and demonstrate or try to demonstrate lack of prejudice. I mean, there are these cases saying you can't show it either way, so the burden of proof turns out to be the whole ball game. I'm not sure about this. It's about this statute and these questions, like whether I don't know when that rule applies, is all I'm saying.
But what we do know here is, in effect, the judge took away any of the protections, any of the protections of Superior Court Rule 6 in allowing attorney-conducted voir dire. I was relegated to being able to ask one question only: can you be fair and impartial? And I submit that
That seems a little strong. I don't read the judge to have told you that exactly.
Well, he already declined to let me ask any of the 12 questions on the juror questionnaire, all of which I...
That's not the same as saying, so the only question you can ask is fair and impartial.
Well, no.
In fact, you asked a couple questions later on, not many, but a couple.
Yeah.
And I think you allowed them, right?
But here's the point. The real questions that got to the meat of the matter were all of those that were on that jury questionnaire. Now, the defense points out I didn't ask many questions of most of the jurors. It's true, because I couldn't think of any more questions to ask. They were all on that jury questionnaire. And beyond that, I was told I could ask, can you be fair and impartial? I submit the court, the trial judge, did not allow a fair opportunity for voir dire.
So are you saying that if the judge had let you be the one to ask the questions instead of him, that would have been better?
No. What I'm saying is the list of questions that I had submitted, not only did the judge decline to ask them, but he told me, you don't ask them either.
Well, that sounds right. He had denied your request to ask him. So, right? So I can see why he would say that. But you're saying that covers what you wanted to ask everyone. And so what were you left with?
Not much.
Counselor, the docket sheet reflects on July 19th.
I'm sorry, Your Honor, I just didn't hear you.
The docket sheet reflects on July 19th that there was a hearing in front of Judge Tabbitt, and it says, after hearing, the court will impanel as agreed by the parties on the record. What's that about?
Candidly, I can't remember. I remember Bert Tingle was the defense lawyer at that time, and he became elevated to the Superior Court, and so the trial was off. I don't remember if there was an explicit ruling on the motion for attorney-conducted voir dire. I just don't remember.
Okay.
Your time has expired, but if there are further questions, I see none. Thank you very much. Very interesting argument. We will hear now from Attorney Wygand.
Yes, good morning. Really 3 points this morning. Number one, I don't believe the issue has been adequately preserved due to the failure to file a new motion for a new trial. Number two, I do not believe this was an effective denial of attorney participation in voir dire amounting to a clear abuse of discretion or clear error of law. And three, even assuming any error, there has not been any demonstration of prejudice.
How can you ever show prejudice?
As to the prejudice, Your Honor, I start with that there was no objections to the questions that were asked.
No, his objection is to the questions he wasn't allowed to ask. He asked if he could ask them and was told no.
True.
He's supposed to then say it again?
Well, no, but you have to look at it in the context of what the jurors were told. And in this case, it's substantial that, and there's no argument otherwise, that the questions that he did ask subsumed a lot of the questions that were contained in the proposed questions by the plaintiff. There's no dispute that the judge's questions that he asked went to the issue of bias, and it included medical malpractice actions. If we go through the questions that were asked, you can see that they were substantially covering the issues that he wanted, that he complains now on appeal. They were asked whether there was anything in the description of the case that gave them the concern. They were all well aware this was a medical malpractice action. They were asked whether they had any strong feelings about people who seek monetary damages. Did any of them have a negative experience with healthcare providers? Did they ever file or consider filing a lawsuit against a healthcare provider? And any medical condition related to what they thought was inadequate care. Not just them, their family members, or any close friend. When you combine that with the absolute opportunity to ask follow-up questions, I don't think you can deduce that there was either an error or prejudicial error. All the jurors that were questioned answered unequivocally. He hasn't pointed to one instance where any particular juror exemplified some risk of prejudice or impartiality. And I think that's part of the failure on the issue of prejudice. As you probably noted, there were 24 jurors subject to the voir dire. 9 were excused by the court. 15 were subject to questioning and not excused by the court. Out of the 15, plaintiff's counsel only asked questions of 2.
When is there ever an abuse of discretion in denying attorney-conducted voir dire?
Fair question. I actually think there's a case I cited out of state, a Utah case. I think it's a situation where a trial judge says, no, I'm not even using your questions, and you're not permitted any follow-up. I've got it covered.
So you think follow-up is the only thing that's required?
I think, as Judge Ditkoff mentioned, the rule said if you provide reasonable follow-up. The mandate here is to allow a fair opportunity. And while it's argued here that he was denied that, I don't think that's a fair reading of the record.
One of his questions was, some people have difficulty sitting in judgment of another. Do you think you could do that?
You're asking me about that question?
Yeah, what's wrong with that?
I don't think it's an improper question.
You don't think, I don't think it is either.
Right.
So why wasn't he allowed to ask it?
Well, I think the judge, well, I don't think that's exactly how he phrased it.
I agree the phrasing is, I don't know how you want to put it. It asks more than that. Will you be able to carry out this? I mean, it's actually not, it doesn't push toward medical malpractice cases need to be treated equally as all other cases. You know, it's not like that. I mean, it's more prolix maybe than it needs to be.
Right.
But the judge didn't ask a question like that.
But what he did do was he took both, he didn't ask any of that the defense asked. He took the questions and he felt and put together his list. And like I said, as I read to you those, they encompass medical malpractice. They encompass experiences related to malpractice.
But the whole point, I think, of attorney conduct, I don't know what the whole point is actually, but I think one of the points of attorney-conducted voir dire is to maybe drill down a little more on the particular case and not just ask a question everyone's going to, well, everyone who's willing to sit is going to say yes to, because of course we do see jurors say, no, I can't be fair, can I leave now, right? We do see that sometimes in impanelment of juries, but anyone who's being straight is likely to say, of course I can be fair and impartial. But then if you maybe say, oh, well, the victim is this race and the defendant is that race, could you still be fair and impartial? Sometimes you get an answer that's a little shakier, and it's good information to know.
And I think everything you just said is absolutely true. And here, again, we have the judge's questions. He had the right to follow up. I don't read the record as he was limited to only asking, quote unquote, are you fair and impartial? I don't think that's a fair reading of that record.
Okay, I'm still focused on the ones that he proposed
Well, I guess I would come back to, as far as the ones proposed, maybe another judge would say, I'm going to let you have some of these. This judge didn't. And the question really is that an abuse of discretion when you consider the questions that he did ask? And so I would submit it's not. And the other element is, counsel was allowed to follow up.
But you've also said the only thing that would be, I think you're saying, consistent with that part of the rule, is to not allow follow-up. That's all you have to do, and you can reject literally any other question.
I guess the caveat I'd add to that is, what did the judge do? Besides not...
No, as long as the judge asks if they're fair and impartial, and can be fair and impartial in a case like this, that basically all this, do you have any feelings against medical malpractice? Would you tend to favor a doctor? And so on. All of that, even, do you think that you could pass judgment on someone? You're saying none of that needs to be asked. As long as the judge says this abstract...
I don't think that's this case. Again, I don't... He asked the questions that he did. He allowed follow-up, and there was nothing that precluded the plaintiff's counsel from saying, oh, Judge, making an offer of proof as to the leaning one way or the other case, if he felt it was so important, or demonstrating why it wasn't subsumed in the questions that he asked, or just pursuing other questions that he could have pursued as far as eliciting bias, either from the questionnaire or anything else about the particular witness. And as on the issue of prejudice, the one witness where he was precluded on that question never sat. He never exhausted his peremptory challenges, so this is not a situation where he had to use a challenge on a juror for cause and was left with no challenges to otherwise challenge another juror he would have otherwise done so. And that, I think, it's the Commonwealth versus Hines case. He didn't use them all. So there's an element that doesn't show any prejudice.
Well, except
and I
I assume his response would be, I didn't know where to use them. I couldn't ask them the questions that I wanted to ask that would have allowed me to use them. It's not that it's not that I used them all on all the jurors who were answering my question. I love doctors, and I was kicking, for some reason they wouldn't go out on cause, and I was doing this, right?
I just think you have more of an obligation. Okay, the judge issued a rule. I'm not going to let you ask the leaning toward one way or the other. I think you got to, if you're really concerned about bias, then I think you still have an obligation at that time to ask other questions or to discuss with the judge. Judge, I need to ask this question. Here's why. Your questions aren't sufficient. Give the judge more basis to adjust his ruling. None of that was done here. And so I submit that there was just no abuse of discretion or any clear error of law. The last issue on prejudice, that you have to look at all of the evidence and jury instructions that were given to the jury. And if you look at the judge's instructions at the end of the case, you can see that he covered issues of bias. And he covered, he asked them in the voir dire, you need to be honest. You need to carefully listen to the questions. You need to decide the case on the evidence and the law. You need to be completely fair and impartial. You need to listen to your fellow jurors and not be swayed by prejudice, personal likes or dislikes, or personal views of the claims or defenses. Is that perfect? No, but it does cover it. And where is the showing of prejudice? Where is there showing that one juror here, all of which answered their questions unequivocally, was remotely biased? So for those reasons, I suggest there was no error and no reversible error. And unless there's any other questions, I would defer to my brief.
I see none. Thank you very much. Interesting case. Excellent arguments, both of you. Thank you.
Thank you.
The next matter we will hear, I can get my things in order, is number 22-355, L&S Realty LLC versus Karen R. Merritt and others. I gather there will be a division of time on the appellee's side, is that right? And you will be splitting your time 4 minutes for Mr. Cronin and 11 minutes for Ms. Merritt, is that right? Okay. We will hear first, though, from Attorney Entner.
Good morning, Your Honors, and may it please the Court. Would the Court like a brief recitation of the relevant procedural history of this matter before I go into my arguments?
I think we're pretty familiar,
Okay.
having dug through all of this with the procedural history, but we'll
one-
ask you questions if we aren't.
Very good. Thank you, Your Honor. I do think there is one procedural note to make briefly, and that is that on February 1st of 2022, Justice Singh entered a single justice order that sort of addressed the idea of whether or not the appellate court should stay the motion to strike or the striking of the appeal that was pending in the trial court, or whether it should hear first the appellate bond. Justice Singh determined that the motion for the appeal of the appellate bond order should wait pending that motion to strike that was pending in the trial court. And it's an opposite ruling and an opposite view of the procedural appropriateness of what was happening at the time from that ultimate decision by
That
Justice.
order issued after the dismissal?
That order
I
issued.
thought the motion to dismiss came in on like January 7th or 5th or something like that.
The the striking of the appeal
Yes.
was actually on February 3rd, Your Honor.
So it's before that order.
That's correct.
Okay,
And it
so-
was in response to the defendant's appeal of the appellate bond order. When the appellate bond order was issued in early January by the
Judge
trial.
Singh just said this stuff's pending in housing court, come back after it's ruled on. We talking about 22J35, the February 1st order?
That's correct, Your Honor. Justice Singh says, rather than take up the issue of the appellate bond and the single justice review of the appellate bond, let's wait and see what happens with the motion to strike at the trial court. That's
Right.
different from what Justice Sullivan then says in his order. In Justice Sullivan's order, he says the trial court,
Her order.
I apologize. Justice Sullivan, in her order, she says that the trial court should not have heard the motion to strike because there was a pending notice of appeal on the appellate bond, and that the proper procedure would have been for the appellate bond order to have been heard first by a single justice, then it would have gone potentially back to the trial court.
Well, why isn't that right? Why did you move to strike the appeal when the tenants, for lack of a better word, had an appeal bond, an appeal from the appeal, petition to set aside the appeal bond was pending?
The motion to strike was predicated on primarily two issues. First was that we believed that their notice of appeal from judgment was untimely or incorrect. But secondly, and perhaps most importantly, they failed to pay use and occupancy. And our position in this case has always been that the use and occupancy order from the trial court is different and distinct from the order from the appellate bond.
Right, so
And under what authority can you dismiss an appeal for failure to pay an ongoing use and occupancy order in the trial court? I don't get that at all. I understand why if they don't pay the bond and the use and occupancy in the bond order, the punishment may be dismissal of the appeal. But what makes you think that the failure to pay some earlier order has anything to do with our jurisdiction over an appeal?
There is some case, Your Honor, there's some case law that we cite in one of the footnotes of our appellate brief, and I believe I can find that quickly here, that does speak to the idea that a trial court can dismiss or strike a notice of appeal for failure to abide by previous standing orders of the court, including use and occupancy orders.
And did that order say that the penalty for not paying would be dismissal of the appeal?
The
Is
order
that due
from the trial
process?
court, Your Honor?
Yes.
The order, which order from the trial court,
The
Your
one
Honor?
that you're now saying is the critical one, not the December 31 order, but some earlier order.
Very good, Your Honor. The order that struck the appeal says in relevant part, despite multiple warnings from the court concerning timely payments of use and occupancy, the defendants have failed to heed either the prior court order for timely payment of use and occupancy, but also the requirements of payments under the bond order.
I understand that, but the bond order was on appeal to the single justice at that moment.
And our argument, Your Honor, is that the use and occupancy is a pre-existing order. It existed
Look,
from the very start.
you got to be straighter with me than this. Are you saying it was dismissed for the earlier order? And if so, where was their warning that you could get your notice or the authority for dismissing a notice of appeal to this court for not paying some ongoing thing in the trial court? Or are you saying that it was the bond order, which is how I understand it, because otherwise I don't know how he can be dismissing or she an appeal. A bond order, I get how you dismiss an appeal for not paying that.
I think in order to answer Your Honor's question, I need to back up a little bit and discuss the history of the use and occupancy in the trial court case. The use and occupancy was ordered early in the trial court case.
We know what was ordered, but you seem to be arguing that the way it works is that if you order use and occupancy pre-judgment and someone doesn't pay, that you just do everything like you normally were doing, but then you can't appeal. And if that is what you're proposing, you're going to need to provide more argument on why that's a sound way to run this railroad. Because I would think that the normal remedy for not paying a prejudgment use and occupancy would be an immediate issue of judgment, or perhaps striking of a counterclaim or something else. I wouldn't have suspected the answer was you just go like a normal summary process, but then you can't appeal it. So if that is what you're suggesting to us, I need more why that's a good idea.
I think the reason for why that's a good idea, Your Honor, is laid out in BNY Mellon, where they discuss the fact that use and occupancy, ongoing use and occupancy payments, even during the pendency of an appeal, are important to preserve the property rights of the party at issue. BNY Mellon, in that case, it was the foreclosing entity that purchased the property of foreclosure. There were amicus briefs from interested parties that said, in a situation where a third party purchases, which is like this, it's unfair to that third party and their property rights, their substantive property rights in that property they have purchased, to permit the holdover possessors to stay for free for a prolonged period of time or for any period of time.
That makes sense, but that doesn't explain to me why the remedy is to allow you to stay for free during the whole summary process procedure going on as normal, but then not let you appeal. I don't see the connection.
So during the trial court process, after the order of the use and occupancy, they repeatedly failed to pay, which drew motions to strike from our client. In response to those
motions to strike what?
Motions to strike their jury claim.
Okay.
See, that makes sense.
Makes sense.
Yeah, that
It does.
sounds like a good remedy for that.
In response to those motions to strike, they then paid. Notably, they never made a payment before we filed a motion to strike.
How is that notable? The judge could still have said this is late and kicked it out, but apparently didn't, right?
But that gets to the judge's order where he says, despite repeated warnings about paying on time and heeding my warnings, despite repeatedly violating my previous orders, notwithstanding orders of the court, they have failed yet again to do it. And under my discretionary authority, I'm going to strike their appeal.
Is that pre-judgment order even operative? Right, there's a new order, the post-judgment order for bond and use and occupancy. It does say they have to continue to pay use and occupancy, but it seems to me a post-judgment order on which the appeal is conditioned, failure to do that can clearly lead to dismissal of the appeal. But that was on appeal to the single justice, so it shouldn't have been, it should have been wrapped up before the single justice, before the lower court decided to dismiss the appeal.
Your Honor can view it in one of two ways. First, the use and occupancy was owed as of January 1st. The appellate bond order didn't issue until after that.
No, the appellate bond order issued December 31st.
It wasn't received by any of the parties until
It's
early
dated
January.
December 31st. I think it's on the docket. December 31st.
That certainly wasn't received on that day. I get that.
So it's our position, so you can view it as they still owed January 1st, the use and occupancy payment for January 1st.
Under what order?
Under the pre-judgment order.
But a judgment has entered. What's the court doing? And there's a notice of appeal, so the court doesn't even have any jurisdiction, does it?
The
We
notice.
do.
At that point, they hadn't filed a notice of appeal for the appellate bond order because they hadn't received it yet.
No. On the judgment, they filed a notice of appeal, right?
Correct, Your Honor.
Okay.
But it's our position also, it was our position also to the trial court judge that that notice of appeal was untimely.
And you're saying it was untimely because it was 2 days premature from the judge's amended order?
Correct.
But since they're not challenging the amendment, I always thought that if there was a judgment and you appeal it timely, then even if it gets amended, as long as you don't have a problem with the amendment, your earlier notice of appeal is effective. Is there anything that says it's not? That's news to me.
The relevant case law, I believe, Your Honor, in regards to summary process cases is very specific, that if the appeal, that premature notices of appeal are completely null and void and they cannot be carried forward.
But it's not premature. There's a judgment, they file a notice of appeal, and then after that, the judgment gets amended. But if they don't have a problem with the amendment, why do they have to file a new notice of appeal?
The prior notice of appeal is rendered a nullity by the motions under Rule 59 and Rule 60.
Oh.
If those are substantive
but-
motions.
What about the SJC case law that tells us not to take that seriously, like Roca?
There
And
are
the-
cases that take it seriously and there are cases that don't take it
The
seriously.
defendants filed that notice of appeal after they received the judge's denial of their motion to amend.
Correct.
So isn't that what they're appealing from?
We still had a motion to amend as well, and it's our position that hadn't been ruled on, that wasn't ruled on until the 17th.
But isn't Justice Ditkoff right that the most recent and binding on us opinions of the SJC say we have discretion to hear these premature notice of appeal cases? And if we have discretion, we can't have lower courts striking them. We have to look at them and decide whether to exercise discretion. I understand why any normal lawyer wouldn't know that, maybe, right? Because it never comes up and so on. You know what I mean? I mean, these are new cases.
Are you saying that Judge Sullivan didn't have discretion to consider the notice of appeal timely filed?
We didn't argue that particular position in our brief because we do feel that given the recent case law and relevant case law, we think that Your Honors do have that element of discretion. That's why we focused our brief largely on the use and occupancy payment and the authority of the trial court to strike the appeal for failure to comply with pre-existing orders. And I think that's important for one particular reason, and that reason is $62,500, which is how much money my clients are out as a 2-year appeal has gone forward and they've received no use and occupancy payments and no
But
appellate
that's,
bond.
I mean, as Judge Sullivan told you, all you had to do was say, hey, you shouldn't have struck this, have the appeal appeal held. Some kind of use and occupancy would have been ordered. They wouldn't have paid, and you would have had the building, 2 years ago.
And particularly given the fact that Judge Sullivan, back in April of 2021, had already denied their petition from an appeal bond. So why, if you had just done what Judge Sullivan said to do,
Well,
be out by now.
what Judge Sullivan ordered was that either party may go back to the trial court for a motion to reconsider the motion to strike. So essentially what I'm understanding is
But you won the motion to strike. Why would you want it reconsidered?
exactly correct.
To
And we already
actually,
have
to
pending-
actually get them out of the building in a prompt manner, which is what would have happened if you had done that.
Well, it's our position also that we are already in 2 appeals at this point from that. This is a consolidated appeal. There are 2 pending appeals. If those had proceeded in a more timely fashion, perhaps it would have been resolved in time. We did motion this court for use and occupancy, or the panel for use and occupancy, and that motion was denied because it was considered an element at the heart of the appeal issue. But it's resulted in exactly what the court in BNY Mellon feared, which is defendants, and may I say, all 4 defendants, despite only 2 of them appealing, staying for free in a house that has been adjudged to be valued.
Right, but the reason that happened is because there's an appeal bond order, of which there's a timely appeal, and the judge here dismissed the appeal, seemingly for failure to pay that appeal bond, without the appeals court hearing it. And Judge Sullivan told you right away, someone needs to fix this. And if it had been fixed and a single justice had heard an appeal bond order, I don't know what they would have done, but they certainly would have ordered some use and occupancy. And assuming that that it wasn't paid, the appeal would have been dismissed and the property would have been yours long ago. I don't think you can blame this on Judge Sullivan.
Well, again, it's our position that the use and occupancy, while reiterated in the appellate bond order, is a pre-existing order of the court that they failed to comply with and that the trial court judge struck under his authority.
But they have a right to petition, to appeal from the appeal bond order. And by moving to strike, you deprive them of their appellate rights.
Your time has expired, but I think we may have more questions. This is an incredibly complicated
Yes.
and, at least for us, very interesting case, probably not for all of you, but it's really interesting.
I found it intellectually fascinating. It's our position that because they failed to comply with the pre-existing use and occupancy orders from the trial court, and because that is a continuing order under sort of the penumbra of the appellate bond order, and because it has already been reviewed at a prior time by Judge Sullivan and found perfectly fine and not an abuse of discretion from the judge's perspective, that they could perhaps get an appellate review and be entitled to an appellate review of the appellate bond, but the use and occupancy has already been ruled on by a single justice.
It was ruled on, though, under 231-118, which didn't necessarily say it was right, but said it wasn't a clearly erroneous order. It's very limited review, that kind of review. And what's problematic is, we accept this appeal bond system because there is a way you get in front of an appeals court judge before your appeal gets dismissed. And if we accept what you're saying, what is the remedy? Where do you get in front of an appeals court judge before your appeal gets dismissed? If we had the remedies we were talking about, immediate issuance of possession, then someone could appeal that and eventually a panel would see it. But the way you've put this together with this prejudgment use and occupancy order, stopping the appeal, someone loses their rights without ever seeing an appeals court judge. What am I missing? Where's the appellate remedy in that situation?
They are entitled to an appellate review of the striking of the appeal. I believe that's what
That's what this is.
But that's not what Judge Sullivan was. Judge Sullivan specifically states in their order that they don't have the authority to do that. That it has to go up to a full appellate panel for that. And they kind of kick them back into the appellate court, and they stay everything.
But it's
pending.
not a single justice matter. The striking an appeal is a regular appeal. Bond order, there's statutes that give the single justice authority.
Right. But where the appeal was struck for failure to comply with the pre-existing order of the court, we're outside of that appeal of the appellate bond order. We're now into an appeal of the motion.
If that's a permissible penalty for not paying it, can I ask you, I know your time has expired, but is the question of indigency before us?
That gets a little bit to some of my broader points that I didn't get a chance to get to, which is I don't believe that this appeal in any way, shape, or form is appropriate to be broader about the specific issues of the case or the substantive issues of the trial court case. I think it should be limited to whether or not the striking of the appeal is appropriate. Where it gets to the indigency matter, we did address that in our reply brief, and I think that because it goes towards the use and occupancy orders, it is perhaps appropriate.
Are the use and occupancy orders in front of us, or they have to go to the single justice?
The use and occupancy orders have already gone in front of a single justice, not after the conclusion of the case or the entry of judgment.
The bond order with the use and occupancy, doesn't that have to go before a single justice, or are we supposed to address it now?
I don't think it's procedurally appropriate to address it. I think the only thing that this court can address at this juncture is the striking of the appeal. As to the indigency...
But do we have to determine whether the prejudgment use and occupancy order was proper in order to determine whether the appeal was properly struck under your theory?
I don't believe that this court has to make that decision or address that because it has been found proper first by Judge Sullivan in April of 2021, and then also under the case law of BNY Mellon that states that use and occupancy arises whether there is an appellate bond or without an appellate bond. So under relevant case law and under the law of the case from the single justice.
We know one can exist, but do we have to determine whether it was the right amount, it was a reasonable amount, and whether these were proper sanctions?
I think that was properly before Judge Sullivan in April of 2021, whether it was the right amount.
Denial of a 231-118 does not prevent you from raising it on appeal, because it's a very limited remedy. So
I think the standard for the use and occupancy, for reviewing the use and occupancy order and the appropriateness of it would be something similar to what the Commonwealth test established and what was later reiterated in BNY Mellon, which is a comprehensive, fact-intensive look at the situation of the parties, the value of the property, the condition of the property, all of which the trial court judge did in this originally in his
The original use and occupancy, well, has that order ever even been appealed? Oh, that was appealed, just the 118 to Justice Sullivan in 21.
That's correct.
I see, okay.
That's correct. Getting to the question from Justice Rubin about indigency, I don't think that the indigency argument in this is properly framed. This wasn't an indigency hearing. They raised the idea of indigency as a household under in opposition to to the original use and occupancy order and also
Only
to a
two of them have appealed.
I'm sorry.
Only two of them have appealed.
Correct.
Each of those two says they're indigent.
Correct.
Is that question before us?
I don't think that that question is appropriately before this court
Okay.
under the motion to strike that was decided by the trial court judge.
Okay, or under the appeals from the single justice orders that we have before us?
Correct.
Okay.
Because, Your Honor, I think that the indigency, the framework for indigency put forward by the defendants in this case is a cherry-picking sort of version of indigency that's mostly meant to address court
Okay, but
costs.
we don't have to figure out whether there's such a thing as collective indigency.
I think the trial court judge did properly look at them as a household in the same way that
Properly or improperly, but we're not supposed to.
I don't think it's particularly relevant. I think the failure to pay the use and occupancy is important
Your
enough.
time has well expired, although there may be more questions. We all set? All right, thank you very much. As I said, it's a very interesting case to us.
Thank you.
Thank you for an excellent argument. You've clarified a lot of things for us, which is very helpful. We will hear next from, at least in the order this is listed, Mr. Cronin. We understand how difficult it is for a non-lawyer to appear before a court, so take your time and tell us what you want to tell us, and we will listen.
Good morning, Your Honors. My name is Charles Cronin. Thank you for giving me the opportunity to be heard. The Affidavit of Indigency ensures complete confidentiality. At the bottom of the Affidavit of Indigency form, it states, "By order of the Supreme Judicial Court, all information in this affidavit is confidential. Except by special order of a court, it shall not be disclosed to anyone other than authorized court personnel, the applicant, applicant's counsel, or anyone authorized in writing by the applicant." To which the opposing counsel received no permission from myself or family to review our affidavits of indigency. On May 4th, 2021, in complete violation of GLC 261, Section 27B, Indigent Court Cost Law, Judge Mashad granted the right of opposing counsel to cross-examine myself and family's affidavits of indigency. My brother Joseph Cronin and I filed under Section A stating we received government assistance with proof, which requires the court to accept it with no further inquiry into our indigent status, as the government has already deemed it so. And I quote from Mashad, "The Cronins had filed various affidavits of indigency, and L&S wanted to have an opportunity to attack the underlying affidavits of indigency. There were requests for financial information that were made by L&S and responded to," end quote.
These affidavits that you were challenging, these were affidavits filed in the trial court for permission to proceed without paying costs, or were they about this bond appeal?
I believe they're about paying for cost,
Okay.
as I'm not completely sure
Okay,
of all the
that's all right.
details of this.
No, we can look at them and we'll be able to tell.
Personally, I felt my rights were violated by Mashad, and it was a bias towards L&S during this. Even when my attorney, Eric Renner, tried to object to the allowed attack, Mashad overruled him, allowing Attorney Garbow to continue his examination. As a result of this hearing, Judge Mashad stated the following in his appeal bond order. Finally, defendant Charles Cronin, who was apparently running a business at the premises and had recently received a COVID grant from the government, the court did not find his arguments advanced by the defendants to be particularly credible. Firstly, I do not own a business and have never received a COVID relief grant from the federal government. This information is completely wrong. Not only were we subject to this attack, but then accused of being not credible. We appealed this unaffordable appeal bond of which the lower court was to put the case together and send it to the single justice for review, which they did not do. Instead, Judge Mashad skipped the entire single justice appeal process and just dismissed our appeal for non-payment. This type of discrimination based off our income is completely egregious and a violation of our Massachusetts constitutional rights, according to Article 11, which states, every subject of the Commonwealth ought to find certain remedy by having recourse to the laws for all injuries or wrongs which he may receive in his person, property, or character. He ought to obtain right justly and freely and without being obliged to purchase it, completely and without denial, promptly and without delay, conformably to the laws. Therefore, I see these framers surely did not want my family and I to be attacked by a judge whose job was to uphold these laws. Thank you for your time.
Thank you very much. We will hear now from Ms. Merritt. And again, as I said to Mr. Cronin, we know how difficult it can be for a pro se litigant to appear before a court without the training and so on that lawyers have. So tell us what you want to tell us and we'll listen.
Okay, thank you. Thank you. Okay. Good day, honorable judges. First, plaintiff wants this to be about how they had a right to dismiss my appeal in violation of statutory procedures to protect our rights to appeal an unaffordable appeal bond order, the function and purpose of which is to deny us our equal rights to access to the higher courts. To address the above issue, here follows the single justice order of Judge Sullivan on March 8, 2022. After review of the Housing Court's docket in the filing described above, it appears that the defendants did not receive the benefit of their January 7, 2022 timely request for review of the appeal bond order. This was an error. See GLC 239-5FG. Nonetheless, the defendant's notice of appeal from the judgment has been struck by the Housing Court for failure to pay use and occupancy under the appeal bond order as to which there was a right to review. The appeal from the judgment has been dismissed, and an appeal of this dismissal has been filed. I lack the authority of this juncture to vacate the dismissal of the appeal, a claim of error which must be presented to a panel on appeal, and am also without authority to correct the error regarding the request for review of the appeal bond order because the appeal from the judgment has been dismissed. Because I conclude that the defendants have a likelihood of success on the merits of their appeal of the dismissal of the appeal and would suffer irreparable harm should a stay on the levy of the execution on the judgment for possession in Southeastern House of Court's docket, etc., not be granted. To the extent the defendants request a stay of execution on the underlying judgment pending their appeal from the order dismissing the appeal, the motion is allowed. No further effort shall be undertaken by the plaintiff to levy on the execution pending the defendant's appeal of the dismissal of the appeal. Now here follows the heart of the matter, standing, and thus jurisdiction, which is always before this court, every court. Briefly, here follows my story. In 2010, I and James Cronin were divorced. Judge Nisi at the Probate Family Court awarded me Rehoboth and Norton property, free from mortgage payments for 4 years. I was a stay-at-home mother for most of my marriage, volunteering at schools and giving to the community. 4 months later, and this is the Great Recession.
Free of, you mean your ex-husband was supposed to pay the mortgage?
Yes.
Okay.
Thank you for asking. Michael came to me 4 months later, and through my divorce, I just want you to know that I was 20 years married. The divorce hit me very, very hard. I was in therapy 3 times a week. 3 children. It was a challenging time. It was the Great Recession. So there's lots of for sale signs around, and people are really having a hard time. Mike came to me. He couldn't afford the hefty mortgage payments. We were halfway through a 30-year note. I had about $600,000 in equity between the 2 properties. Greco is my accountant, From 2002 to 2010, he was our accountant and our financial advisor. I trusted him completely. He made promises that he would fix our finances and starve, this is what I understood, starve off the upcoming foreclosure, which, unbeknownst to me, we were only 3 months behind and yet to seek loan modifications or accounting of our real estate holdings, which we had holdings. We had another large piece of property in Rhode Island. Sitting at the so-called closing, my sacred trusted accountant beside me had me sign a hard money loan for $311,500 that he brokered to his brother-in-law Fagan and his business associate Turnin, ignoring Judge Nisi's order that Mike was responsible for the mortgage payments. I received no money, just promises. When I was sitting there, I had no intent to purchase a loan. I was signing, believing that my accountant and Mike were going to take over the mortgage payments. That's all my intention was for. That is it. The hard money loan was doomed to fail. It had a balloon payment that was due in 2011. I didn't work. How was I going to pay this? In 2011, I didn't get the GLC 245-385 default notice, which would have provided me 150 days right to cure. This is instrumental. I wouldn't be standing here today if I had gotten my 244-35-8 default notice in 2011. I could have said, wait a minute, what the heck is this? I not only didn't get that, from 2011 to 2017, Greco and Turnin worked alongside Mike at their business in Rhode Island, assuring him not to worry about the payments. Let's just keep working. Then in 2017, they threw Mike out of the building, locked the door, stating that he had been an employee. Immediately after that, they sent us our first GLC 245-35A notice stating that they had accelerated the hard money loan from 2011 and that I owed then approximately $850,000. I had yet to discover at that point that Turnin and others had compounded the interest loan and violated Chapter 271, Section 49, the statute that prohibits usury in the Commonwealth. As of 2017, Turnin and others willfully, knowingly brought this criminal, illegal loan amount through bankruptcy court, land court, and Southeastern Housing Court. How do I know that Turnin and others had the intent to continually, willfully, and deceptively conspire to try to collect on the usurious hard money loan? Turnin and Fagan admitted in a bench trial in October 2021 with the Honorable Stearns in the U.S. District Court of Massachusetts that they charged compounded interest on the subject loans and concealed it from me for years and then foreclosed on my home. Turnin's final GL 245-35A default notice number was $1.3 million. My home was foreclosed using a compounded approximate 55% interest rate. This is 4 times the unenforceable hard money loan for $311,500. How can I cure a default in 2017 on wildly inflated numbers that are usuries? It was grounded in an invalidated, accelerated 385 default notice, which I never received in 2011. I'm done. How can I do that? To top it off, Turnin and others are willfully and intentionally still pursuing a deficiency on this, and they know it's a criminal usurious interest rate. They've already testified. They know. Thus, on December 5th, 2019, when Turnin held what looked like an auction and supposedly sold my home to the highest bidder, L&S Realty, Turnin and others willfully and knowingly conspired to commit an unlawful foreclosure. At that supposed eviction, my then attorney went to L&S Realty, gave him his card and said, "This is a contested title. If you continue, you're going to get yourself into a lawsuit." I've been completely transparent in everything that I have done. L&S Realty, then using the same lawyer as Turnin and Fagan, Godbout Law, brought a civil action to the Southeastern Housing Court, announced that they had title and that I was trespassing, which then later morphed into a summary process eviction case. L&S Realty didn't file in a title clearing court, Superior or Land, to fix their title issue. As they had been notified by me that I'm going to challenge the title. You are way out of line, you guys. Rather, they claimed that they had the title, and I filed a summary process eviction case, which is used for those parties who have no title issues or landlords and tenants. See Warren versus James, 1881. I'm not their tenant. The lower court made the following errors in my summary process case. The judge erred by denying my 4 counterclaims and affirmative defense, grounded in the mistake that I was past the statute of limitations and thus barred from getting equal protection under the following laws. Firstly, if it please the court, 271, Section 49, criminal usury, deemed a per se violation of 93A, the Consumer Protection Law. Pursuant to Chapter 27149C, any loan at a rate of interest prescribed under the provision may be declared void by the Supreme Judicial or Superior Court in equity upon petition by the person to whom the loan was made. Therefore, the lower court erred by stripping me of my rights to petition to the SJC or the Superior Court. Next, pursuant to the Predatory Home Loan Practice Act, MPHLPA, Chapter 183C, I have a right to seek protection under its vast array of glorious provisions as a consumer. Section 5B2 provides that a borrower may employ a defense claim or counterclaim during the term of a high-cost mortgage loan.
Okay, Ms. Merritt, your time has expired, but if you want to wrap up, I'll let you go on a bit.
Okay. This isn't, okay. God, okay. The court maintained, however, that they were not entitled to judgment of Chapter 183 as a matter of law because the 5-year statute of limitations in MPHLPA 15B1 bars all of our counterclaims. However, the court erred for 2 reasons. Turnin is still pursuing a deficiency. 2, under a post-purported foreclosure according to the holding SJC Morris decision, my case meets the language during the term of the high-cost mortgage.
Now, you understand, we're hearing what you say, and it sounds like you've been through something terrible.
Thank you.
Of course, those issues, the lawfulness or unlawfulness of a foreclosure and the consequent summary process action and its outcome will be addressed, depending on what happens with the appeal bond and use and occupancy, which we have to decide first, in an appeal from that judgment. So we're not addressing any of that in this case. We're only addressing whether the appeal should have been dismissed and what the single justice said. And that will require us to deliberate and figure out what's going to happen. But it's not right now about those merits that you're talking about, although I understand what you're describing.
Thank you for your warmth. I appreciate that. I'm confused, though. May I ask a question? Judge Mashad, I say his name improperly, pardon, ordered interim use and occupancy when he dismissed in error my counterclaims. If my counterclaims, if the judge had not made that error, he couldn't have made interim use and occupancy.
So I don't know, you're now describing an earlier order of the judge that it also isn't before us now. So I don't know the answer to those questions or whether those issues have been resolved in prior proceedings or not. All I'm talking about is that before us right now is the dismissal of the appeal and whether that was appropriate on any of the grounds put forward by L&S, and the orders of the single justice and whether they were appropriate or not. And there are arguments about those from L&S. And once we've decided that, either they were appropriate and that appeal is dismissed, or they weren't appropriate and that appeal can go on pending questions about the, the bond amount and the use and occupancy amount. But that's all we have before us. So we really appreciate what both of you have to say, and I think we understand it.
I have one question, if that's okay.
Sure, yeah.
Ms. Merritt, we have a rule that says when there's two parties on the same side who file separate briefs, they're allowed to adopt the briefs of the other person. And I just wanted to know whether it was your intention, in addition to your own brief, to adopt Mr. Cronin's brief.
I don't really understand the question. I'm sorry.
Do you want to make just the arguments in your brief, or do you want to make the arguments in Mr. Cronin's brief? I don't mean orally, but do you want us to consider as if you made them?
Please consider my son's brief.
Okay.
All right.
Thank you for asking. I appreciate it. Thank you very much.
All right, thank you. And we know, as I said, how hard it is for pro se litigants to come in, pro se representing yourself litigants to come in. So we appreciate your doing so. And of course, we appreciate counsel's assistance in our proceedings. We always do. Thank you, Your Honor. So thank you very much. The case is submitted. The final matter before us today is number 23-227, DeSautels versus Board of Appeal on Motor Vehicle Policies and Bonds. We will hear first from, I will mispronounce your name probably, Ms. DeJunis. DeJunis.
Good afternoon. I think the best place to start here is with the language of General Law, Chapter 90, Section 22C, which is a statute that authorizes the Massachusetts RMV to take action on a Massachusetts license based on something that happened in another state. And the language starts, if the registrar receives official notice in any form. I think that's what the problem in this case is, that there was never any official notice. The state of Vermont never contacted the Commonwealth of Massachusetts and said, hey, there's a conviction here, a guilty adjudication, or any case at all with regard to the OUI. And I think that's what the problem is.
But they did send official notice of the negligent operation, right?
Yes, but not of the OUI charge. And so
But 22C says, official notice that any person licensed to operate a motor vehicle on the revision of the statute have been convicted in any state of a motor vehicle violation. Doesn't say of an OUI.
I don't know what you're...
It says of a motor vehicle violation. If you get official notice of a motor vehicle violation, it doesn't say it has to be an OUI violation.
I'm not sure where you're reading from, Your Honor. Is it from the record?
Statute you were just reading me. 22C.
Oh, yes. I understand. I just wanted to direct the court's attention to the provision that says official notice, and that official notice was not received in this case. And I think that illustrates where the problem is that the RMV was relying on a few documents provided by my client. But if you look at those documents, either individually or collectively, they don't really show substantial evidence that a conviction was had. If you look at how we impeach somebody with a conviction, We get a certified court record. We don't rely on somebody bringing in a dismissal on a quaff and say, oh, well, there's a dismissal, therefore this person must have necessarily have admitted to sufficient facts. That's not the way we do things. But I think the easiest way to do this might be just to look in the impounded record appendix and go through the documents one by one. If you look at the impounded record appendix starting on page 15 and 16, this is the Vermont driving record, and there's no indication on there of an OUI.
No, of course there's no indication because it was expunged and the conviction was stricken. And I know there's a question about whether it's a conviction or not, but what that order striking it says is the conviction is stricken. But let's take it as stricken. And let's assume, although of course I will ask opposing counsel, let's assume that stricken convictions don't count. You don't have to be convicted. You could also be assigned by a court to a treatment program. And it appears, although it's certainly not crystally clear, it appears that in Vermont, rather than doing this quaff thing that we do here, which has always seemed a little odd to me, on file, whatever that is, instead of doing that, they actually enter a, whatever you want to call it, we don't have to call it a conviction, but this judgment-y thing. And then if you complete the probationary conditions, it's stricken. And the probationary conditions here include doing whatever your probation officer says. And then one of the things your probation officer could say is, go get some treatment for your substance abuse problem. And then the only question we're left with is, well, did the probation officer say that? And we have a letter from this therapist in Worcester to the probation officer describing what's going on. Now, it's not an inescapable inference, but it's probably a reasonable one that the Worcester therapist wouldn't be sending a letter to the probation officer directly with private clinical information in it, unless, I mean, certainly if it were authorized by it must be authorized by the patient, but still, or client, whatever it's called in that particular therapy, but still, it's a reasonable inference, I would think, that it must be that the probation officer has required the client to see this, or some psychotherapist or therapist, whatever, and that this therapist is now reporting back. So why isn't that assignment to a treatment program? And therefore, even if that isn't a conviction, this still counts.
Well, I think I want to back up to the very beginning of your question because I don't agree with a central component that you're relying on. And number one is that the order of expungement somehow affects what happened at the Vermont DMV. It does not.
So if it was a conviction, your position is the expungement doesn't mean, it's actually stricken. I don't know the difference between expungement and stricken. Stricken seems more aggressive than expungement to me, but all right. Even though it's stricken, you would agree if there was a conviction, even a stricken one, that counts.
Well, I don't think that's what happened here.
I understand that.
So my argument here is that there's not substantial evidence that a conviction or an adjudication of guilt had occurred. There's no official documentation. The documents that were submitted are inconsistent. So the order of expungement doesn't apply to the DMV.
Yeah, but inconsistent, if it's a substantial evidence test, how does inconsistent help you?
Well, because the substantial evidence test is such evidence as a reasonable mind might accept as adequate to support a conclusion. Do we determine that somebody was convicted based on a few documents from a court file? I don't think we do. I think we need to see some official...
Well, one of them is expunging a conviction. So that might be a good document to at least say a reasonable mind might reach the conclusion there must have been a conviction here.
Except that the order of expungement does not apply to the DMV. It applies to law enforcement, prosecutors, and the judiciary. That's impounded record appendix page 17.
I think it also says that for all purposes it will be as though this person was never convicted.
Except that the DMV did get notice of this, so the DMV did know
I
at some
thought the
point
DMV
if
got,
there was a
you mean
conviction.
our RMV or you mean the Vermont DMV?
I mean the Vermont DMV, which never reported an OUI to the Commonwealth of Massachusetts. So the DMV knew about this, right? If this
Which-
is evidence of anything, they knew about it because
which
the
one?
order of
Wait, wait, wait.
expungement was sent
Wait,
to
wait,
them, but it didn't.
Please specify which DMV.
The Vermont DMV.
Okay.
Okay, so I'm looking at the impounded record appendix, page 17. So the Vermont DMV knew that there was some sort of case on this. This order does not apply to the DMV. Leaves me with the question, why didn't the Vermont DMV notify the Commonwealth of Massachusetts of this if there was a conviction or an adjudication
Is it your
of guilt?
position that it cannot be relied on as the fifth conviction or whatever number we're talking about here, sixth or fifth, because of that change in the law, I guess fifth, that it can't be the fifth conviction because it wasn't reported by Vermont to the Commonwealth, that the only way the Commonwealth may become aware of a conviction that counts is if it's reported by the other state?
I don't think that's an absolute requirement, but again, starting with the statute that authorizes Massachusetts to take action.
Well, now
it's
they
upon
know,
official
now
notice.
they know it happened.
Well, but I'm not sure that we do know that it happened because
We know something happened.
something happened, sure, but is there substantial evidence of a conviction? The type of evidence that we rely on to determine whether somebody's been convicted. We don't rely on random documents from a court file.
I don't understand. Don't we use documents from a court file to determine whether someone was convicted? Isn't that the only way to do it?
Well, a certified copy of a court record, sure. These documents are not
Have a
certified.
rule that the board is not allowed to accept anything but a certified copy?
I do not have a citation for that, Your Honor.
I thought your client submitted these documents.
He did submit these documents.
Are you claiming they're not authentic?
Well, I'm saying my client as a layperson does not understand the legal impact of what he did or the documents that he gave. But looking at these documents, is this substantial evidence of a conviction? I don't believe that it is.
One of them says the adjudication of guilt is discharged. So how could that happen if there wasn't an adjudication of guilt? I'm looking at the same one you were just pointing to us to.
So I think the only way that we can get there is to say, well, we have to assume that the Vermont courts did everything right. And I don't think we can say that.
Isn't there a presumption of regularity? Isn't that what we always do? Unless there's contrary evidence, we presume that courts did things properly.
Well, that might be true for Massachusetts courts, but I'm not sure that this court has a presumption of regularity test that's applied to out-of-state courts. And here, where documentation is inconsistent, DMV in Vermont, if there was a conviction, they would have known about it because they at least got notice of the expungement, which is going to give them.
But let's look at the next page of
Right.
this thing, or 2 pages later, page 20.
Yes.
To the Commissioner of Corrections, the above-named defendant was convicted and sentenced as follows. And then it says DUI influence, and then it's a deferred sentence, and then there's all of these things. The above-named defendant was convicted. I mean, maybe he wasn't, but here's a thing from the Superior Court Criminal Division signed by a judge that says he was convicted.
And again,
Now, maybe it's a forgery.
Well, I'm not suggesting that, but it was convicted. That's not even the language that the Vermont courts use. So under the statute, adjudication of guilty, this court's talking about conviction. So flipping to the next page.
Wait, I'm sorry. Where is the phrase adjudication of guilt used in Vermont?
That's the language of the statute that is at issue here. Well, not at issue here, but under which the...
And the order to expunge says the adjudication of guilt is stricken. What's the difference between an adjudication of guilt and a conviction? Isn't a conviction defined as an adjudication of guilt?
I'm not sure that it's defined that way under Vermont law, that perhaps it could
How about
be...
in English?
Well, my point is that the language of this order is not consistent with the language of the Vermont statute. It's talking about a conviction versus an adjudication of guilt. He was not convicted. There was no conviction. Whether there was an adjudication of guilt at any point in time, that's been undone, but under Vermont law, he's
No,
not
this is
convicted.
signed by a judge and says he was convicted.
Which is inconsistent, though.
They don't have
with the other-
convictions in Vermont?
I didn't hear you.
They don't have convictions in Vermont? No
What
one's
I'm saying
ever
is
been
that
convicted?
This would not have been a conviction. At most, it would have been expunged, it would have been stricken. So the language of these documents is not all consistent
But I thought
with-
you said the striking of it didn't matter because the DMV still had it.
The DMV still had it, they didn't report it. I guess my point is that the documents are all over the place. They're not entirely consistent. You have to rely on an assumption that Vermont courts did the right thing and followed their law, and I'm not aware of any
Not just
law that
one
would allow
thing,
this court
right? I have to assume that Judge Karen R. Carroll, who signed this, thought this was correct, and that Judge Teresa DeMoro, who expunged it, did it correctly. We've got a couple of things signed by judges, which
Judges
refer
make
to...
mistakes. That's what appeals courts
Okay, but you agree that it's just substantial evidence is all they need. You don't think 2 signed orders by 2 different Vermont judges gets pretty close to substantial evidence that this is... I mean, it may be wrong. Of course, substantial evidence may be wrong.
It might get close, I don't think it gets us there.
What could be substantial evidence? Even if they had an official Vermont DMV, how would you not know that
They did
whoever
make a
told the DMV screwed up, or that the DMV in Vermont screwed up, or that the judge below, coerced a plea or something? How could you ever have substantial evidence if you have to assume that the out-of-state authority screwed up?
Well, I think, again, restricting it to these facts, and I know these facts are very unusual because I don't think that the RMV in Massachusetts frequently makes decisions to revoke somebody's license based on unofficial documents. I mean, they did not obtain these from Vermont. There was no effort that I'm aware of made to obtain these records from Vermont. And, Your Honor, you had mentioned before about an assignment to an alcohol education program. If you look at the next page...
I understand it wasn't the crash program. It doesn't say that. The condition is a treatment program, a treatment or something else, right? The Massachusetts requirement isn't that it be the designated state anti-alcohol program. If the probation officer said, go see a therapist about your substance abuse problem, I think that would be enough, don't you?
Well, but what this judge ordered here is that my client had to be screened for drug and alcohol use.
And then follow any orders that the probation officer gave him.
Right, but that's not what Massachusetts law says. Massachusetts law does not say if your probation officer determines that you should
It's
get
a
some
court
treatment,
order.
then you
It's
should...
not probation. The court orders you to follow what the probation officer says. That's why you do it, right?
That's why you do it, but giving a probation officer discretion to decide whether or not you require treatment, I don't think would be an equivalent to what a 24D type
It doesn't have to
disposition
be an
here would
equivalent. It just has to be an assignment to a program. What has to be equivalent is the offense.
But the court did not assign him to a program. The court assigned him to do a screening and then gave entire discretion to a probation officer. And I don't think that that satisfies the requirement in Massachusetts. If that happened in a Massachusetts court, I don't think that that would be, just being screened would satisfy the requirements of Massachusetts law. If it doesn't satisfy Massachusetts law, I don't know how it happening in Vermont could then satisfy that component of the OUI law here.
We will ask opposing counsel about that.
Thank you.
If there are no further questions, thank you. And we will hear from you now, Ms. Graney.
Thank you. May it please the court, my name is Jennifer Graney. I'm an Assistant Attorney General representing the Registry of Motor Vehicles and the Board on Motor Vehicle Liability Policies and Bonds. Your Honors, in terms of the practicalities of this, what the case ultimately comes down to is, was this alternative disposition in Vermont at least the equivalent of an alternative disposition in Massachusetts, which would be known as a quaff? And if it was at least equivalent to that, Massachusetts statutes are clear that the registry had to treat that event as countable for purposes of driver's license revocations. So that, I think, is the practical piece of it in terms of...
Does that mean you're not relying on the word conviction, you're relying on the other?
We're relying on both in the alternative, Your Honor. I think either way, the outcome is the same.
Do you think a stricken conviction can count?
I do, Your Honor, and the reason is because the statute that's being interpreted here is Chapter 90, Section 22C, and Section 24(1)C. Those direct the Commonwealth to treat the event or the conviction as if it had occurred in Massachusetts, as if the same thing had occurred in Massachusetts. Here, that type of alternative disposition would be a quaff, and a quaff is very plainly a conviction under Section 23(1)D, which is the definition of conviction. That is very clear from the law because 24(1)D was actually amended to make that entirely clear. There was a discrepancy between the law applicable to commercial drivers and regular driver's licenses under 24. So it's very clear that a quaff in Massachusetts is in fact a conviction, and that's why we argue that this is a conviction and the court need not reach the issue of assignment to a program. However, if the court disagrees as to whether this event was a conviction under Massachusetts law or as to whether it should be considered at all, then it is also true that this was an assignment to a program. Under the same language in Section 24(1)C that is repeated in all of those sections, including 3, 3 3/4. Assignment to a program is not specifically defined. It's not defined as requiring the exact equivalent of Section 24(D), which is the Massachusetts statute involving alternative dispositions and involving the type of program that is permissible if a quaff is going to be the disposition of the case. So, and in fact, it would not make any practical sense for the definition of assignment to a program to be limited in that way because, plainly, many different states have many different ways of providing alternative dispositions in this situation. And if that definition were read so narrowly, the other language in the same statute, not only in 22C, but also in 24(1)C, that other language that requires the court to consider events from other jurisdictions would be rendered superfluous and would not make sense. So it has to be the fact that assignment to a program, because it includes assignment to a program in other states, isn't coextensive or required to be the same program as in Massachusetts.
How do we know he did get assigned to a program by a judge? We've got this report that he completed a program in December of 2014, but that's well before any judge made any order.
I'm sorry, Your Honor, your question is that the report from...
Well, we know he was in this AdCare Hospital IOP program, but he completes that in December 2014. And this probation order is in March 2015, so it's after that. So that couldn't have been... I mean, I understand the probation order allows assignment, but how do we know it happened?
So, Your Honor, the evidence for that is in the second volume, the impounded appendix. And firstly, it is the deferred sentence probation order that's at page 19 and 20. That is the document that is signed by a judge of Vermont that states that Mr. Desautel was convicted and provided with probation and that he must follow certain conditions as required by his probation officer. Then the next document at page 21 shows in the second table that the probation officer checked yes for a substance abuse assessment and yes for substance abuse counseling. And then we have the letter that Justice Rubin mentioned directly to the probation officer, giving the probation officer in Vermont a report on Mr. Desautel's counseling and his progress. So those documents collectively demonstrate that he was assigned to a program for purposes of Massachusetts law, even though it was not the same as would occur in Massachusetts.
34.
34?
It's a few months later.
Got it. Okay, that's what I was missing, the document on 34.
Can I ask a question? Embarrassingly enough, I've never heard of the Board of Appeal on Motor Vehicle Policies and Bonds until, well, receiving these briefs. Are its proceedings adversarial?
Yes, they are, Your Honor. I have not attended, to be frank, but usually there is a representative of the registry there, and then the person who is making.
So the registry, it's not that the board has its own prosecutorial part and like SORB or something. It's the registry comes in and says, this is what we think, and it's contested before a hearing examiner of some kind.
Yes, that's correct, Your Honor. It's usually a panel, usually of 3 people.
And they are hearing examiners or?
The panel, the board is appointed, and there are various.
Oh, I see, I see.
Requirements in the statute, but various.
And does the registry have the ability to, does it have subpoena power? Can it get documents and so on?
The registry most certainly has subpoena power in its own hearings. I know that from another case. I believe under just general principles of administrative law in Section 14 of Chapter 30A, there is an ability for the agency, I'm sorry, it wouldn't be in 14, but there is an ability for the agency in Chapter 30A to issue subpoenas for administrative hearings.
Is there a way for the registry to get the actual records from Vermont so that we're not like looking at this scattershot like, oh, here's a document from 2 months later or whatever?
To that, I would say, of course, I would think it is possible to request certified records. I think in this case, what would have happened if the registry asked for records from a court in Vermont is that they would not have received the records because
of the expungement order.
And the way that the interstate compact is supposed to work, that should not be necessary. And further, I would also say that.
Because they're supposed to have reported this to you in the first place, or not you, but to the registry.
Under the interstate compact, which both Vermont and Massachusetts have adopted, these types of infractions should be reported to each other state. I cannot explain why they
Well, there's an explanation. This plea agreement signed by a prosecutor in Vermont says no reporting of conviction to DMV. I mean, it's outrageous, but.
I guess what I meant, Your Honor, is I can't square that with the fact that Vermont is also a participant in the interstate compact. And I also can't explain why there was such a delay. For example, the reckless driving charge was reported to Massachusetts through the interstate compact, but not until 2020, even though it had occurred in 2015.
And it just happened by happenstance. It's not that anyone was like trying to get something from Vermont and all they got was that.
My understanding is the reckless driving just came in, and then there's an automatic 60-day suspension for that reason. So, Your Honors, I think it's clear that there is evidence in the record, and it is sufficient to be substantial evidence. That, of course, is a very forgiving standard, and much deference is given to the agency to find that substantial evidence.
Where's the burden in the hearing? Is it on the challenging party or on the registry?
It is on the challenging party. And there is a site for that in the brief. The challenging party at all times has the burden before the board, and then, of course, going forward before the court. Lastly, I would just say about the question of legal error, that as usual, the usual rules of administrative practice apply here, that an agency is given great deference in the way that it interprets the statute that it is charged with enforcing. So to the extent that there are questions as to how Section 22C or Section 241C should be interpreted, as long as the agency's interpretation is actually reasonable, it should not be displaced by another interpretation. And that is clear through numerous cases that are cited in the brief. I'd be happy to answer any other questions. If there are none, I'm happy to rest on the Commonwealth's brief.
I see none. Thank you very much. Excellent arguments from both of you. We appreciate it very much. That completes our sitting for today, and consequently, we stand in recess.